Welcome to Chapter 3, Federal Courts. This slide deck is a longer slide deck, and so we will move relatively quickly through the slides. This is a very important chapter, and so I want you to focus and pay attention as closely as possible. This chapter will cover principles of U.S. court organization, the history of federal courts, United States district courts, United States courts of appeals, United States Supreme Court, other specialized courts, federal judicial administration, federal court caseloads, and attacks on the federal judiciary. What are some principles of court organization? Well, in the U.S. court system, it's complicated and very technical. A language of the courts exists. And really, there are three important organizational principles: that of jurisdiction, that of a dual court system, and that of trial and appellate courts. First, jurisdiction. Jurisdiction is the power of a court to decide a dispute. Generally, this is geographical jurisdiction, where certain courts have authority over certain specific geographies. Geographical jurisdiction is when an event occurs on the border of two jurisdictions. There's a dispute about where to hear the case sometimes arises. Extradition involves the surrender by one state or country of an individual accused of a crime in another jurisdiction. So there's geographical jurisdiction. There's also subject matter jurisdiction. Many courts are limited to cases dealing with particular substantive issues. So, for example, misdemeanors or small claims or bankruptcies. There's also hierarchical jurisdiction. Courts differ in their functions and responsibilities. So original jurisdiction means that a court has the authority to try a case and decide it. Appellate jurisdiction means that a court has the power to review a case that has already been decided. Appellate courts may have some limited original jurisdiction. In our system, we also have a dual court system. America has one national court system and separate court systems in each of the 50 states. Federal courts are located in every state and territory. Organizationally, the U.S. courts operate in a similar manner throughout the country, but they are often different in their interpretation of the law. Sometimes state and federal courts share judicial power over certain cases. What's the difference between trial and appellate courts? Well, most all cases, civil or criminal, begin in trial courts. The losing party at the trial court level may request an appellate review of their case. An appellate court ensures that the trial court correctly interpreted and applied the law. The principal difference between trial and appellate courts is that a trial centers on determining the facts, whereas an appeal focuses on correctly interpreting and applying the law. Table 3.1 in your book shows the court systems of the United States and the routes of appeal. Let's think for a minute about the history of federal courts. Federal courts reflects our federal system of government. The history of the federal courts begins in Article 3 of the United States Constitution and the Judiciary Act of 1789. The Articles of Confederation lacked a national court system. There was widespread agreement that a national judiciary be established. So Article 3 was a compromise, creating a Supreme Court, but other federal courts only as Congress deemed necessary. The Judiciary Act of 1789 was the first bill introduced in the new United States Senate, and it provided the foundation for the current three-tier system of federal courts, that is, a Supreme Court, appellate circuit courts, and 13 district courts. The act was both a victory for the Federalists and a product of compromise. District court boundaries were drawn along state lines. By custom, district court judges would be residents of those districts. Lower courts had limited jurisdiction. The history of the federal courts from 1789 to 1801 includes the Judiciary Act of 1789, which was a temporary compromise. Federalists pushed for the Judiciary Act of 1801, which eliminated circuit riding, created many new judgeships, extended lower federal court jurisdiction, but it was repealed after the election of Thomas Jefferson in 1801. Table 3.2 shows you the original federal judiciary of 1789. The Court of Appeals Act of 1891 created the courts of appeals as the culmination of one of the most enduring struggles of American political history. The debate was about state or federal resolution of problems, and it continued throughout this time period. Since 1891, little has changed in the appellate court system. The basic structure today, district courts, courts of appeals, and Supreme Courts, is a function of the 1789 and 1801. I'm sorry, it should be 1801 laws. I'm sorry, 1891 law. So if you go back to that slide, forgive me, it's 1789, 1891 Court of Appeals law. You can see here in Table 3.1 key developments in the federal judiciary, a timeline from 1787 with the adoption of Article 3 of the United States Constitution, all the way to some of the more pressing and immediate developments in the federal judiciary, all the way up until 2008. Let's think for a moment about United States district courts. There are 94 United States district courts, 89 in the 50 states, 1 in D.C., and 1 each in Guam, Puerto Rico, the Virgin Islands, and Northern Mariana Islands. There's at least 1 district court in each state. No boundary crosses state lines. Many hold court in various locations called divisions, ranging from 1 division all the way up to 8 divisions. There are 667 judges in the United States district courts. They're nominated by the President and confirmed by the United States Senate. They serve during good behavior. The United States district courts are divided into large districts and may have a federal public defender. Each district has a United States attorney. The United States attorney is nominated by the President, confirmed by the Senate, but serves at the pleasure of the President. They prosecute violations of federal law and represent the government in civil cases. 3-judge district courts are a special type of district court. It's a policy issue as it interacts with court structure. It's created by Congress to prevent single federal judges from deciding certain cases, such as voting rights cases. And it's created on an ad hoc basis and disbanded after any one case has been decided. Having a 3-judge district court is a complex process. 3-judge district courts can appeal directly to the United States Supreme Court. Controversy over the years about which and how many cases should go to 3-judge district courts has prevailed. In 1973, 320 cases went to a 3-judge district court. In 2002, 45 cases. And in 2009, only 7 cases. Today, cases are only heard by a 3-judge district court if they deal with legislative reapportionment or if mandated by the 1964 Civil Rights Act or 1965 Voting Rights Act. Table 3.3, you can see, is the federal judiciary as of 2015. You can see in this chart that the state of Texas has 4 divisions in the 5th District Court of Appeals. United States Magistrate Judges assist district court judges in their tasks. United States Magistrate Judges were created by the Federal Magistrates Act of 1968 to reduce the workload of district court judges, and in 1990, Congress acted to call them judges in fact. United States Magistrate Judges raises certain constitutional issues. Magistrate judges perform quasi-judicial tasks but are not Article 3 judges. Today, magistrate judges perform a wide variety of duties depending on its jurisdiction. Another United States District Court is the Bankruptcy Court. These are district courts, and they're aided by 352 bankruptcy judges. Bankruptcy Reform Act of 1978 allowed for bankruptcy cases to be filed in bankruptcy court. Bankruptcy judges are presidential nominees who receive Senate confirmation and have a 14-year term. In 1982, a Supreme Court decision changed the way bankruptcy judges are appointed by making them appointments by the Court of Appeals. Let's think about the caseload of the district courts for a moment. Trial courts of original jurisdiction caseloads is large and growing. In 2014, 404,875 criminal and civil cases were filed. Only 63,316 of cases were criminal, which means the vast majority of district court cases are civil cases. Many cases involve federal questions, diversity of citizenship, or prisoner petitions. What is a federal question? Well, it's a case that contains a major issue involving the United States Constitution or U.S. laws and treaties. Most involve a congressional statute like Social Security or labor or civil rights laws. Federal questions increase in civil caseloads, and it's a function of more legislative activity. So, for instance, Americans with Disabilities Act is a recent example of the expansion of civil rights, which led to more court cases. Federal questions and other common federal questions include cases involving voting rights, patent claims, copyright infringements, naturalization proceedings, and admiralty disputes. Diversity of jurisdiction involves suits between citizens of different states or a U.S. citizen and a foreign country citizen. Table 3.4 shows a graph of the increase of appellate court and district court cases over the years. Diversity jurisdiction applies to state, not federal law, and constitutes approximately 25% of the civil docket. In 1988, Congress increased the amount in controversy for diversity jurisdiction from $10,000 to $50,000 in dispute, which reduced the number of cases. In addition, district court cases hear prisoners' petitions. In the United States District Courts, we have what's called a prisoner petition, or in state court, what's called habeas corpus. These typically involve allegations of illegal confinement, ineffective counsel, conditions of confinement, or inadequate medical assistance. In 1996, Congress passed limitations to habeas corpus petitions. Let's think now about the United States Courts of Appeals. Created in 1891 to reduce the Supreme Court's workload, there are 13 courts of appeals, 11 regional, 1 Washington, D.C., and 1 federal circuit court. There are currently 179 judges nominated by the President, confirmed by the Senate, and served during good behavior. Size of the court varies. There are 6 justices on the First Circuit, while there are 28 justices on the Ninth Circuit. It varies based on workload. Each circuit has a chief judge and a staff, including a circuit executive. Each judge may hire 3 law clerks, and there is also a central legal staff. Normally, a Court of Appeals uses 3-judge rotating panels. It may include visiting judges, which are primarily district judges, and senior judges, which are retired from active practice. By a majority vote of all judges in the circuit, they may sit together en banc to hear or rehear a case, typically less than 100 of those cases per year. The caseload of the United States Courts of Appeals is very limited within original jurisdiction. Some cases are directly from administrative agencies. Mostly the courts hear appellate jurisdiction cases over criminal and civil matters. The United States Supreme Court is the highest court in the nation. There are 9 justices on the court, 1 Chief Justice and 8 Associate Justices, who are nominated by the President, confirmed by the Senate, and serve during good behavior. Most cases come to the Supreme Court through a writ of certiorari, an order to the lower court to send up the case records to the Supreme Court. The Supreme Court reviews decisions by U.S. Courts of Appeals and state courts of last resort, like the Texas Supreme Court. The court mostly decides which cases it will review, and frankly chooses to review a small minority of cases that are petitioned. Cases often involve conflicting legal doctrines, and despite the small number of cases that are decided, the decisions are very important, setting policy and legal precedent for the entire nation. In addition to the Supreme Court and Courts of Appeals and district courts, there's also specialized courts. Congress has created specialized federal courts that are authorized to hear a limited range of cases like taxes or international trade. Most have permanent, full-time judges appointed to that court, while others borrow judges from district or appellate courts. Here in Table 3.3, you can see a list of specialized federal courts. I, for one, am barred or allowed to practice in the Court of Federal Claims, as well as the Court of International Trade. Article 1 and Article 3 status. Judicial bodies established by Congress under Article 3 are known as constitutional courts. So that would be Supreme Court, district courts, and courts of appeals. Judicial bodies established by Congress under Article 1 are known as legislative courts. So that's bankruptcy courts and tax courts. There's an important difference because Article 3 judges serve for good behavior, while Article 1 judges serve for a fixed term. Article 3 judges are protected from salary reductions while in office, while Article 1 judges are not. They're subject to the whims of the budgetary process. Constitutional courts enjoy a greater degree of independence, while some Article 1 courts have been turned into Article 3 courts. In 1982, the Court of Claims and the U.S. Courts of Customs and Patent Appeals were combined to form the U.S. Court of Appeals for the Federal Circuit. Specialized federal courts are largely unknown to the public. They're politically significant, however, because they involve cases such as international trade, intellectual property, and government contracts. Expansion or contraction of the number of and type of specialized courts is a function of certain interest group politics. Let's think for a moment about military justice. September 11, 2001 brought attention to issues of military justice. Military justice is based on the 1950 Uniform Code of Military Justice, which created the Court of Military Appeals, which is composed of 3 civilian judges appointed by the President for 15 years. The 1968 Military Justice Act further refined the practice of courts martial. Military justice applies to members of the military and civilian employees and applies on and off a military base. It provides determinations of innocence or guilt, but also enforces order and discipline. Military tribunals are being planned for many enemy combatants captured during the War on Terror. The use of military tribunals for non-military individuals is quite controversial. The federal judicial administration began with a haphazard administrative structure. In 1922, Congress created the Judicial Conference at the urging of Chief Justice and former President William Taft. The Administrative Office Act of 1939 created the current administrative structure we have today. The Chief Justice is a supervisory authority over the federal system. The Chief Justice also acts as spokesperson for the federal court system. The administrative policy-making organization of the federal judicial system is the Judicial Conference of the United States. Members of the Judicial Conference include the Chief Justice, the Chief Judge from each Court of Appeals, 1 district judge from each circuit, and the Chief Judge of the Court of International Trade. The Judicial Conference meets semi-annually for 2-day sessions, and most work is done by committee. The conference directs the administrative office in administering the budget, plays a role in the impeachment of federal judges, and revises the various rules of federal procedure. The Administrative Office of the U.S. Courts was created by the Administrative Office Act of 1939. The Administrative Office presents the annual budget, allots authorized funds, and supervises expenditures. It also collects statistical data on the operation of the court system that's published in the annual report. The Federal Judicial Center was created in 1967 and conducts research and training activities. It also provides education and training of federal judicial personnel and provides oversight by a board, including the Chief Justice, Director of the Administrative Office, judges from the U.S. District Courts and Courts of Appeals, and the Bankruptcy Court. Judicial Councils are basic administrative councils of any given circuit and have authority to make all necessary and appropriate orders for the effective and expeditious administration of justice within its circuits. It is authorized to investigate complaints of judicial disability or misconduct. The U.S. Sentencing Commission was created by the Sentencing Reform Act provisions of the Comprehensive Crime Control Act of 1984. It's an independent agency in the judicial branch that establishes sentencing policies and practices for the federal court system. It also develops, monitors, and amends sentencing guidelines, conducts training, research, and informational programs for the judiciary. There are many ongoing federal courts caseload controversies, but early in the nation's history, most all judicial business was handled by state courts. Over time, the federal caseload grew with the Industrial Revolution, Prohibition, the New Deal, the Great Society, and civil rights legislation. Federal caseload growth is nothing new but it has accelerated over the past 30 years. In fact, critics complain about judicial gridlock. To understand, plan for and control the growth of the federal judiciary, Congress created a special study committee which published the report of the Federal Courts Study Committee. It recommended over 100 changes to the administration of the federal court system and blamed Congress for expanding federal jurisdiction. Historically, the police power of Congress has been reserved to the states. Congress has been extending federal criminal and civil jurisdiction and police power for years. Efforts to expand federal jurisdiction are often tied to partisan and ideological positions. Federal judges tend to oppose the federalization of state crimes. The Supreme Court has even challenged congressional expansion of federal criminal court jurisdictions in the U.S. v. Lopez case in 1995 and U.S. v. Morrison case in the year 2000. There have been and will continue to be attacks on the federal and even the state judiciary system. Opponents of the federal judiciary in particular suggest an inspector general to investigate judges, tougher disciplinary measures, limitations on lifetime appointments, and impeachment of judges who make unpopular decisions. In conclusion, the federal courts have substantial power. There are many debates that continue about what cases the federal courts should hear. And to some, the federal courts today hear too many trivial cases, but to others, the federal courts should be open to average citizens to sue on any number of matters. The federal judiciary today is undisputedly much bigger and more important than ever before.